Sanibonani babukeli emakhaya. I'm Leonard Tsikedi and you are watching uMkhonto Wesizwe Updates channel. The MK Party recently announced Dr. Hlophe as their leader in parliament. The MK Party later handed Dr. Hlophe's name as a nominee to serve in the Judicial Service Commission. This sparked many debates across the country. Some saying Dr. Hlophe should not be considered as a member of the Judicial Service Commission because he was impeached as Judge President. Others say that there is nothing that legally prohibits Dr. Hlophe from being elected as a member of the JSC. Dr Oxtoby, who is a research consultant for Freedom Under Law, and Mvundlela Nkosana, who is a president of Black Lawyers Association, locked horns in a debate on the question, is there anything that precludes Dr. Hlophe from becoming a member of the JSC, legally speaking? Let's hear what their stance is on this.
The very short answer is yes, but not. It's not directly contained in the provision that you've cited. One has to look at broader provisions of the Constitution overall, and I'm happy to elaborate on that. But if you want a short yes or no answer, then that's my position.
Good morning to your viewers, and good morning to Chris, and good morning, Eldrin. Legally speaking, in terms of the provisions of the Constitution, no. If you reason it from the fact that the drafters of the Constitution could not have foreseen a situation that arises like this, where you're sitting with a former judge then wanting to participate in the politics. But what is worse, an impeached one, not somebody who decides post retirement that I want to now participate in politics.
Okay.
So I think one has to look at Section 165, which requires all organs of state, including Parliament, to act in a way to protect the judiciary, to protect the independence of the judiciary. I think one has to look at the importance of the judiciary in our entire constitutional framework, the extent of the powers that the judiciary is given. One then has to look at the importance of the JSC in obviously appointing judges. In that context, I think to have an individual who has been found by, incidentally, these same organizations to have committed gross misconduct and to be unfit for the role, to have him then serve on the body that is involved in the selection of judges, I think is not only inappropriate, but I think it is legally challengeable. Of course, it is quite correct that there is not an express provision in terms in the Constitution that precludes this. I think, as was correctly stated, I don't think this is a scenario that was foreseen, but I do think that looking at the Constitution holistically, I think it does give us a basis to say that actually this would not be an appropriate appointment. So I think it would severely impact public perceptions of the credibility of the appointment process. I think that's really the essence of it. I think it would create an impression that there is a blurring of law and politics, which, I mean, as we know, there is always going to be a certain overlap between the two. But we do try and keep distinctions in place between them. I think it would be harmful for public perceptions, for the credibility of the judicial appointments process and therefore the judiciary itself. And that potentially undermines the very independence of the judiciary itself if the judiciary is not perceived to be independent.
Yeah.
Look, the expanding it to that extent actually even gives you more problems within the context of how we have structured the Constitution holistically. And if we look at how we have structured this Constitution, in the BLA, we start from a point that says, when we structured this Constitution in 1993-94 and its adoption in 1996, can we really say that we anticipated that we are going to have this kind of challenges? In all probability, no. And the very same persons going to serve in Parliament, in all probability, particularly as judges, know, because we know very well that the state is constituted by the three arms of the law. It's the judiciary, it's the legislature, and the executive. Now, when one comes from one set to go and serve in the other, and that person has been declared by that very body that they can't serve in the other body, then it gives you even more a challenge. But you see the danger, what Chris talks about as public perception. The danger is that in South Africa, you can't do anything unconstitutional on the assumption of the fact that you are worried about that body may be tainted. One, you are sitting with a body that is constituted in terms of the constitution itself. And when that body is constituted, parliamentarians sit in that body and they take decisions on the basis of voting in that body. And the JSC does not necessarily appoint judges. They recommend judges for appointment by the president. So to the extent that they would that kind of difficulty will arise, these perceptions that Chris talks about, you can't erase them overnight. Judge Hlophe's issue as it unfolds in courts and also in the public space has thrown the spanner in the works in the manner in which we are interpreting our law versus our moral high ground as a society, to the extent that we are able to say, if you did this, why should you then go to the other side? Go to the very same processes where former persons who served sentences are now currently in parliament. And then all of a sudden they are appointed to actually participate in certain committees of parliament, and those committees may be dealing with the whole justice issue. What happens then if that person did not even believe that the judgment against them in court was whatever? So I'm just saying that the cross-cutting nature of our constitution, applied vertically and horizontally, does not give us opportunity to say Judge Hlophe cannot participate in the... What I'm saying is that your direct translation of the Constitution does not give you that opportunity to go that route because of these realities of society. Yes, Judge Hlophe currently still sitting in courts, and that very question would arise: what happens if he succeeds in his argument in those courts? But we know that he has not succeeded in those courts. To the extent that Parliament had ended taking this decision, it means that process on its own, up to now, at least this, pending the decision by the Constitutional Court, which is currently asking as to whether those judges that are sitting there are conflicted or not, whether they can preside over his matter and so forth, are conflicted. If that matter ends with a conclusion that he is impeached, but he serves in Parliament, why do we think that if he can serve in Parliament, he can't serve in the JSC?
Yaze yanzima-ke indaba ka-Dr. Hlophe. Looks like the MK party will always be taking blows and being fought at every turn. But yeah, it was expected. All the best to Dr. John Hlophe. We need his brilliant mind in the JSC. Well, that is all from us today. Please show your support to this channel by pressing the subscribe button, like this video, and share the video link with your friends and family. This is Dr Tsikedi signing out.